My name is Mike Larsen, and I am the president of the BC Freedom of Information and Privacy Association. I'm also a faculty member in the criminology department at Kwantlen Polytechnic University, and that's actually where I am right now in my office at KPU. And I want to acknowledge that this office is part of KPU's campuses, which of course are located on the traditional, ancestral, and unceded territories of the Musqueam, Katsi, Semiahmoo, Tsawwassen, Kaikait, Coquitlam peoples, and of course the Kwantlen First Nation, who gifted this name to the university. FIPA, as an organization, works on unceded traditional and ancestral territories of Indigenous peoples across British Columbia and indeed across Canada. And in doing this work, we strive to recognize the commitments we have to truth and reconciliation, and also to really advancing the specific privacy and access to information rights of Indigenous peoples as allies. So I'm here to, I'm very pleased to share the video version of an event that FIPA recently organized, supported by hosting by the KPU Faculty of Arts, which we're very grateful for. And the event is on Alberta legislative changes, that is, changes in Alberta's information and privacy laws that have taken place quite recently. I'll get to the event very shortly, but first, for those who don't know who we are, the BC Freedom of Information and Privacy Association is a nonpartisan, nonprofit organization that's based in British Columbia, but indeed operates in other jurisdictions and on other issues across Canada. And we're dedicated to advancing and protecting information rights, that's the right of information, and also privacy rights for citizens across this country. We engage in public education activities, legal research, advocacy, law reform activities, and I really invite you to check out our website and to see more information about this kind of event and also all the other awesome work that FIPA gets up to. So on to this event, we're looking at Alberta legislative changes. Alberta, like other provinces and territories across Canada, has information and privacy law, has had for many years. And up until very recently, Alberta had a combined Access to Information and Privacy Act that was kind of consistent with a lot of Canadian standards. But then we entered into November of 2024. On the 6th of November 2024, two Alberta government ministers rose in the Alberta legislature to introduce two very important pieces of legislation, Bill 33 and Bill 34. The Minister of Technology and Innovation introduced Bill 33, which is the Protection of Privacy Act. This is Mr. Glubish. This act was touted at the time as being an effort to modernize Alberta's privacy law and also to deliver, and I'll quote, to deliver Albertans the strongest privacy protections in the country and the strictest penalties for privacy violations in the country. So pretty significant claims there. Shortly after that, on the 6th as well, the Minister of Service Alberta and Red Tape Reduction, that's Mr. McNally, rose to introduce Bill 34, the Access to Information Act, which was presented as another effort to modernize Alberta's law, with a particular emphasis on bringing it in line with some standards across the country, and also with specific acknowledgement of the importance of really recognizing and enshrining cabinet confidences in Alberta's transparency law. Now, combined, these actually represented a major split of the existing legislation, which would be essentially replaced by not a conjoined access and privacy law, but rather by two separate bills that deal with public sector transparency and also privacy. That was November 6th. By the end of 2024, both of these bills had passed, and this means that Alberta goes into 2025 looking at a completely shifted terrain of information and privacy law. And there are many questions that arose from such a transformative, in a short period of time, bit of legislating in Alberta. Questions around the contents and substantive changes that have taken place, around process, around what this means in terms of coming into force and implementation. And so BC FIPA, as part of our Info Summit series, decided that we would gather together a panel of people who would be in a good position to answer some of these questions. And we could think of no better person to kick off our discussion than, of course, the Information and Privacy Commissioner of Alberta. And we also brought in two leading experts in Alberta privacy law, Lorne, Randa of Brownlee LLP, and Samantha Delechantos from Fasken LLP, who will respond to the Commissioner's comments that you'll see in a few minutes here. But first, I'll quickly switch over to the presentation by Alberta Information and Privacy Commissioner Diane McLeod, and I'll invite you to stick around. As we go through this, we'll see the presentation from the Commissioner, followed by some questions and answers from our legal panelists, and then we open it up to some questions from a really fantastic group of participants. So thanks very much, and let's dive in.
So as I was saying, I really appreciate the opportunity to be here to talk about these two bills. So I'm just going to give you a little bit of background as to sort of how we got here. I'm going to talk a little bit about what the bills are saying, more or less talking about some of the new features in the Protection of Privacy Act and some of the amendments to the Access to Information Act. And I just like to say hello to all my fellow access and privacy professionals that are joining us today. And I see that there's a lot of people, so that's great news. And although we are talking about the two latest bills in Alberta, I'll just say that there's a lot happening in Alberta. We have our FIPA review underway right now, and we expect the report of the committee to go to the legislature this winter in our next session, and we're also looking at changes to our Health Information Act. So it's a very, very, very busy time for us in this office, and just like to give a shout out to all of my staff that work with me, because we have been very, very busy doing a lot of recommendations for laws. So with that, I'll turn it over to my discussion about these two new laws. So I'll just give you a little bit of background sort of about how we got here. So in December of 2024, the Access to Information Act, which I'll refer to as the AIA as well, and the Protection of Privacy Act were passed in the Alberta legislature. So the AIA codifies the majority of access to information provisions in what was the Freedom of Information and Protection of Privacy Act. As many of you on the call that are from Alberta today know that the FOIP Act in Alberta came into effect in 1995. And the PPA, which is the Protection of Privacy Act, codifies the majority of the privacy provisions of that act. Once the acts come into force, which we are told might be around May of 2025, that's the goal right now, the FOIP Act will be repealed. So just a little bit of background as to sort of the evolution of the creation of these laws. So as I indicated, the FOIP Act was proclaimed in force in 1995. And between 1995 and what we now have under these two new pieces of legislation, there had been very few amendments to that act. It was reviewed, I think it was around 2011, and there was a number of recommendations made to modernize and strengthen the act at that time, but those recommendations were never implemented in the legislation. There was a few tweaks here and there over the years, but quite frankly, the law lagged behind many in the country. So, the time is definitely now to amend these pieces of legislation. Well, the FOIP Act, I guess I'll just refer to it as that for now. And there's a lot of things happening, as many people know, particularly in the privacy side of the equation. We have the amendments to Bill C-27. We have, as I indicated, our amendments to our Personal Information Protection Act. A lot happening in the international arena, particularly around the GDPR. And of course, we have the advances in technology and the uses of artificial intelligence and generative AI and all the things that are happening right now in the research and development front on technology. So Alberta government has been working towards modernization for some time now. And in fact, before I was recruited to this position, they had done a lot of work on their plans to utilize technology and invest in technology in the sector in the province. So in terms of the fast forward, their plans are to use data to provide client-centered services. This is probably not something that's different in other jurisdictions. Everybody has their sort of flavor that they're looking at to implementing to improve public and health services, for example. The other thing that they're doing is they want to use information derived from personal information to train and use artificial intelligence from both within government and for research and development and the implementation of technology, including AI in the private sector, that could also be used in the public and health sectors. So there's a lot of work and a lot of momentum in the province right now towards those objectives. So actually in 2023, the government established the Department of Technology and Innovation, and its focus is to deliver on these various objectives. So transforming data use in government and then of course advancing innovative technologies in the province. We also have what's called Alberta Innovates, which is the funding arm in the province that is designed to facilitate this work. They invest in research and development, and they work with those involved in that area to try and develop new technologies for use in the sectors that I mentioned. There are many projects underway, and if anybody is sort of looking at what's happening in that space, there's a lot of uptick for the development and use of health technology, which is really not surprising given that we just came out of the pandemic and there's a lot of need to sort of advance more efficient and effective healthcare in our province and I'm sure every other province in Canada. So I mentioned already about Alberta Innovates, so I won't repeat that. But one thing that we just learned about and we have been called to participate in is there's a new project actually in Alberta that's bringing experts from across the country to try and find a pathway to bringing new technology to market. So this work is taking into account what is needed to ensure compliance with privacy laws. So we will be sitting at that table. We don't know what that looks like yet. It's new, and they're just in the process of developing terms of reference. So it'll be interesting to see sort of what comes out of that work as a bit of a roadmap that might be able to be utilized in different parts of the province. In addition to that, in 2024, my office actually launched an engagement strategy with the Technology Development sector, to try and work alongside them and to determine sort of, what they need to ensure that they understand what privacy laws need to be complied with. In our province, we have several. We have the private, the public, and the health. And to try and understand sort of, their language, they can understand ours so that we're, able to communicate effectively. So that work is in progress right now. We do have a couple of startups that we are working with. We are also engaging with Alberta Innovates and other research and development to try and sort of create that engagement. So in terms of the consultation with our office, so we have been aware of what's going on with the development of these two laws since about the very beginning of the conversation within government. So in late 2023, we were actually informed by representatives of the Department of Technology and Innovation that they were going to look at amending the FOIP Act to achieve some of the objectives that I mentioned before about data strategies and technological innovations. So we began meeting, we started talking with them about what they wanted to do. So our goal with that was to try and provide comprehensive comments and recommendations on what we thought a good framework might be on both the access and the protection of privacy side of the equation. We were informed sort of about their goals in terms of their data strategy and with the information that they were able to provide to us, and we met several times to discuss their ambitions so that we had an understanding of what that law might look like. We then provided them with a comprehensive set of recommendations for the amendments to both of those laws, and that was in March of 2024. In the summer of 2024, we were given a policy document that included the wording that would be included in the new acts. So not all of the things that we recommended for amendments to the legislation were incorporated, but some of them were. So we were encouraged to see some of the changes, particularly in the Protection of Privacy Act, less so in the Access to Information Act, which I will talk about in a few minutes here. So in September of 2024, we provided another set of comments and recommendations in response to the proposed acts. and some tweaks were made to the I believe the Protection of Privacy Act and maybe in the Access to Information Act in regards to some of the comments and recommendations that we made. We were never provided with copies of the bill, so we could not see exactly what the bill looked like. And of course, as anyone that works in the legislation field knows, is that the devil is in the detail. So once the bills hit the floor, we were then able to have a really good sense of what they were doing. And we then provided another set of comments and recommendations. And I have two letters. One to the Minister of Service Alberta and Red Tape Reduction, and then the other to the Minister of Technology and Innovation. And both of those letters can be found on my website at www.oipc.ab.ca. So much of what I'm talking about in terms of these bills are things that I set out in my comments and recommendations in those letters, but I will review what I said and provide some additional information about my comments. So I will start with Bill 33, Protection of Privacy Act. So there were things I set out in my letter. One was the positive aspects of the legislation, and then there was a section where I raised some issues for consideration as the bills were moving through the legislative process. So essentially what I said, my letter was dated November 2024, so that was about a week after the bills hit the floor. So what I said was a positive aspect, and I think that many of us would agree that these are positive aspects, and that's privacy management programs. So it's now a requirement for public bodies in Alberta to have privacy management programs. So that's really positive. There's also a requirement to conduct privacy impact assessments. There's also mandatory breach reporting, and the threshold that's been identified in the legislation is real risk of significant harm. So we have a little bit of differing thresholds in Alberta. Our FIPA legislation, private sector, is real risk of significant harm, or ROSH as we often call it. So that means the public sector will have the same threshold to meet. And the benefit of that, of course, is we actually have a lot of decisions on what constitutes real risk of significant harm. So that's a benefit to public bodies trying to determine when there is a ROSH. In our health information legislation, it's risk of harm. So that's a different threshold, but it makes sense in terms of health information. It's very sensitive, and it's important to notify people where the threshold for harm is lower. The other thing that I will comment on about the Protection of Privacy Act is the data provisions. So as I indicated, the government was interested in creating a data strategy to use data for a number of different purposes. And so that is reflected in the data provisions in the Protection of Privacy Act. And so I was pleased to see that there's a framework there for actually guiding how this is going to happen, because as many people know that work in different jurisdictions or even in Alberta, there is many things happening with data, but, there's no real guardrails around, how data can be used and what some limitations associated with its use and consequences for misuse. So I'm going to talk a little bit about the data provisions in this piece of legislation. So what they do is they actually allow the creation and use of new types of data as a result of data matching. So they permit data matching to occur in a limited set of circumstances. So they have limited purposes, research and analysis related to delivery of a program or service, and prescribed purposes, so a little bit of an unknown there. They actually have rules regarding security requirements, source of collection, retention, prohibition on disclosure except to another public body. So this allows government to data match for, say, wraparound client kinds of services. And then there's additional rules associated with when it can occur, how it can occur, and you have to document certain aspects of the data matching that are occurring. So that's positive. At least there's something there. Then we get into the rules regarding non-personal data. So in these provisions, there is the ability, or actually the duty in some cases, to create non-personal data if you want to use it for different purposes, such as those that I mentioned already. And the definition is data generated, modified, or anonymized so that it does not identify an individual. And this includes synthetic data. So here again, there's the same limitations for the purposes of creation. There's rules about how it can be created, and that is going to be left to regulation. That's something that we will be working with government on. Requirements to maintain records about its creation. So that's great. The source of the personal information, the purpose of creating it, the method used, the assessment on the inability to re-identify. So again, good controls in place to ensure that data is in fact non-personal data, and it's still limitations of use and recording requirements. And once it meets all of those requirements, a public body can use it for any purpose once it's created and meets those requirements. And they may disclose to another public body or any other person subject to limited uses and head approved conditions. So the head of the public body. And there is a requirement to include in an agreement the security, prohibition on re-identification, and some other codified obligations that must be contained in that agreement. So again, it's a new world. All of this sounds a little bit scary sometimes, and it is in some cases, but at least we've got some sort of criteria here to look to. Another thing that's positive about the provisions here is that even though it's non-personal data, it is still subject to the Act and Commissioner oversight. So that is positive. I know that was one of the weaknesses in Bill C-27 about the use of de-identified data, is that there was carve-outs and there was no oversight. So I think this is a really positive aspect. Some other positive aspects of the PPA are there is a notice for processing personal information for automated decision making. So if your personal information is going to be used to train an automated decision-making system, you are to receive notice of that under the legislation. There is also a prohibition on the sale of personal information, which is positive. I think that we would all expect that would have been the case anyhow, but now it's in the Act, and a person can be held accountable under the Act for noncompliance. There are also threshold and substantial fine changes for an offense. So under the FOIP Act, it was the threshold was willfully, which is a very high threshold for proving that an offense has occurred. So now it's been changed to knowingly. And what may be of interest to people listening today is that under our Health Information Act, the threshold is also knowingly for an offense. And we have had many successful prosecutions under that act. So that means our ability to actually move forward with an offense with Crown, of course, is more likely under this legislation. Of note, under our FOIP Act, we have never prosecuted an individual, so that this is positive. And when Minister Golubish, that's the Minister of Technology and Innovation, was talking about the strongest privacy legislation, I believe that he's often referring to the offense provisions. So, we do have the lower threshold. We also have significantly higher fines in the legislation. In the FOIP Act, it is between $2,000 and $10,000 for an individual, and any other person $200,000 to $500,000. In PPA, it's for an individual, it's up to $125,000, and any other person up to $750,000. And for the offenses for derived data and any contraventions of the data provisions, an individual is up to $200,000 and any other person up to $1 million. So clearly the offenses are more possible, and the fines are significantly greater. So that does provide some strength to the legislation. So some areas that we will be monitoring under this piece of legislation is there's a lack of a paramountcy provision in the Act, and we didn't understand why that was the case. We actually wrote to the department and sort of asked, hey, did you miss this? And the answer was no, we didn't miss it. We didn't think it was necessary. And their reason for saying that was in the legislation, there is if another act allows the collection, use, or disclosure, then, that should satisfy that there would not be a conflict. We disagreed, and we set out in our letter, about why we think the paramountcy provision actually needs to be included in the legislation. And I won't go into all of the detail, but at the end of the day, we don't have a paramountcy provision. Every other privacy law in our province does have a paramountcy provision. It's actually in the Access to Information Act. It's just not in the privacy one. And so here we are. We don't know what it's going to mean, but once we start doing interpretations, we will have a better sense of that. Another area that I made comments on are the Common or Integrated Program or Service Authority to collect, use, and disclose personal information among public bodies. This is pretty common in most privacy legislation in the public sector in Canada. I did have some concerns about using this for certain data initiatives because there is a lack of rigor around the establishment of common or integrated programs or activities. There's a lack of accountability when it comes to actually being responsible for data protection, access to information. Those things are not clear in our legislation. And there is a lack of transparency around what is happening with data and these common or integrated programs or activities. So I did actually highlight against that in my original set of comments to government. I cautioned them on using this particular authority for their data initiatives because I felt that there was too much risk. This authority came into effect, and of course, back in 1995, and that's when the world was primarily paper-based. There was less ability to share information broadly, which differs today, of course, with our systems, which are integrated and accessible, and there's risk associated with that. I did point them to a couple of models. Those that are on the call from British Columbia will know that under BC's legislation, there is a process for actually determining whether it's a common or integrated program or activity. There also is in Yukon, where I came from before, our Access to Information Protection Privacy Act there actually requires that it go through the Commissioner and Executive Council, which is similar to the Lieutenant Governor and Council here in Alberta. So, there was some hoops that you kind of had to go through in order to establish these programs, and there was transparency. So that recommendation did not get implemented, and there is the ability to collect, use, and disclose personal information for common or integrated programs or activities, which added to the data matching capability. I do have some concerns that we need more transparency around that process. The other thing that we were concerned about is the lack of transparency for data matching. So I did talk about the model, and I do think that the law could be strengthened by ensuring that there's information in the public about what is actually happening with these kinds of data matching that are occurring. I also raised concerns about the carve-outs which exempt communications between political staff and ministers from the Protection of Privacy Act. So I'll talk about a little bit about what's happening in the Access to Information Act in a few moments, but we were a bit surprised to see that the Protection of Privacy Act does not actually apply in certain circumstances to records created by or on behalf of Executive Council, or to records of communication between political staff and the members of Executive Council. And we aren't sure about the policy objective for this, but it is concerning because there is the ability of public bodies to disclose personal information to Executive Council members, and then once that happens, the Act doesn't apply. So we do have concerns about that, and we will be monitoring to see if there are any issues with that carve out of the Act. We were also concerned about the lack of sufficient security provisions. So the PPA has essentially the same security protection requirements as was in the FOIP Act, so reasonable security arrangements. What we're seeing now in more modern privacy laws is actually specific responsibilities to protect personal information with administrative, technical, and physical safeguards, and generally you'll see more detail around what that means. So we have been told that will be addressed in regulation, and we will be working with the government on the development of regulations as we move forward. So we've already started to put together what we think might be a better framework to ensure the security of personal information, particularly particularly in light of the ability to share and match information that's permitted under the legislation. Let's just see here. We also had some concerns about the breach notification provisions are a bit light. We would want to see some provisions about how to assess the harm, the duty to report that to the commissioner, the cause of the breach, and it should also be required for the breach of data derived and non-personal data. So we'll see what happens with that. Again, we'll be working with the government on the regulations coming up here. Another area is the new authority to disclose information of a minor without consent when it is in the minor's best interest. So I won't say a lot here other than to say I had concerns about that. If it really is in the minor's best interest, then I'm not sure why consent can't be sought, or at the very least, this authority could not go forward where there is an expressed wish to the contrary. So we'll be watching that as well. We also have concerns about the dependency on regulations for privacy impact assessment, privacy management programs, and the security requirements. We had concerns about the lack of rights concerning automated decision making. So I indicated there's a duty to provide notice when they're going to use your personal information as part of creating an automated system. But there is a lack of rights correlating with the use of such systems when it may impact an individual, such as the right to object or appeal. We also think that there are broader powers for the commissioner that are needed, such as the ability to investigate compliance with any agreements entered into under the Act, auditing compliance, and making any order the commissioner determines is necessary to enforce compliance. We also have issues with the offense provisions. So the offense provisions, as I said, they're good and they're strong. However, you need to have enough resources in the office in order to proceed with offense investigations. They're time-consuming and resource-intensive, and I do not have enough resources to actually go forward with these kinds of investigations. I made this crystal clear to government as I worked my way through it. I even went to budget committee this year and made it very clear that I do not have the resources to do this work, but unfortunately my plight fell on deaf ears and I did not receive the funding I need. So we are not sure how effective those offense provisions are going to be. So I'm looking at the time here and I'm going to work really quickly through this next part of the Access to Information Act. I will just say at the outset, and if anyone had read any of the articles that the media articles following the tabling of these bills, I made it clear that I was not happy with this particular piece of legislation. My only recommendation about this piece of legislation was that it ought to go back to the drawing table and the rights of Albertans be restored, because there's definitely a weakening of access rates in Alberta as a result of this bill. So just quickly, there's several exclusions for Executive Council records. One of them existed in the prior legislation, but several more have been added. So briefing a member of Executive Council in preparation for assuming a ministry or sitting of Legislative Assembly. And again, this record of communications between political staff and member of Executive Council. Yeah, we're concerned about these. And the other thing we're concerned about is the exception to the right of access for cabinet records. Before, it was the substance of deliberations that were protected, which is understood to be a cabinet privilege. However, in this piece of legislation, it's broader. They also included the subject or substance. They also removed the exceptions to the exceptions for background facts. And they extended the timeline to 15 years as opposed to 5 years. So essentially, taken together, these carve-outs, are the broadest in Canada as it relates to Executive Council related records. I know that the minister had indicated that this brings Alberta in line with other jurisdictions. We didn't find that to be the case. We looked at all the other laws, and Alberta's law is clearly much broader when it comes to the cabinet exception provisions, and which is highly problematic. It essentially undermines to a certain degree the purpose of freedom of information legislation, which is, of course, to keep government accountable and to ensure that we can exercise our democratic rights. There's a couple of other things I'll mention quickly. There are new definitions that may affect the right of access. So they have defined electronic record to include a record a record that exists at the time the access request or that is routinely generated. So if it's not either of those things, then you can't get access to that record. And to me, that's highly problematic because most information today is stored in databases. So if you come along and you ask the government of Alberta for a record, it's not one that exists already or that's not routinely generated, you're not getting access to that record. So that to me is a significant backward step in a person's ability to obtain access to information in a world where information is stored in databases. So we're going to be taking a look at that. The other thing that has changed is how a person can make an access request. So now the onus has shifted to an individual having to provide what they call sufficient information for a public employee to be able to process that request. They have 30 days to provide that information. If they don't provide it within the 30 days, the request can be declared abandoned. And if they don't provide enough information, it can actually be disregarded. So two other things I'll mention on this piece of legislation. So the power to disregard used to sit with the commissioner. So if a public body wanted to disregard an access request, they had to request permission from the commissioner to do that. Under this piece of legislation, that responsibility has now shifted to the head of a public body, and the ability of the head to disregard requests has been expanded from what were 2 circumstances under the existing FOIP legislation for the commissioner to 5 circumstances, one of which includes the request is otherwise overly broad or incomprehensible. That is a significant ability to disregard requests because that is a very broad, or that provision can be interpreted very broadly. So there's that, and what else did I want to say here? Time extensions. Again, there was the public body before could extend their time limits up to 30 days, and then any time extension after that had to be approved by the commissioner. Now, the public body can extend essentially for an unlimited period of time in certain circumstances. Both the time extensions and the request to disregard, or the ability to disregard, I should say, are reviewable. So what that means to me is that it is likely that our office is going to see a significant increase in requests for reviews. And of course, a request for review can go all the way to an inquiry and to judicial review. So it will cause lengthy delays in access to information or even the ability to exercise your rights. So that is a bit disheartening in terms of those particular authorities. The commissioner's powers to compel records has been significantly reduced. I think many people know that we already cannot get access to privileged records, so that has been clarified and expanded in this legislation. And we cannot, also get access to cabinet records, and there's a new attestation process that will be determined by the commissioner and the lieutenant governor and executive council. And it will make it challenging for us to do our job as it relates to any kind of reviews involving those records. So I think I will leave it there. I know that was a lot of information to digest, so I'm happy to answer all the questions that people may have about the acts. And again, it's new terrain in Alberta, and we're really interested to see how these laws will impact access and privacy rights here.
Fantastic. Thank you so much, Commissioner. It really goes to show that it's kind of you've almost done the impossible of getting a decent synopsis of all these things within the limited time we have here, just because of the sheer number of things. And of course, we've got some fantastic questions rolling in here too. But what I'd like to do is invite our panelists to Lorne and Samantha to join us to pop on cameras, and I'll turn it over initially to Lorne Randa of Brownlee LLP to perhaps kick off with some comments and a question.
Thank you, Mike, and thank you, Commissioner McLeod. Interesting to hear about the consultation involvement that the OIPC had with the government in the implementation of these bills, because I know for one, for the legal industry and my large client base of local public bodies, I know these bills came at quite a bit of a surprise that the FOIP Act was going to be entirely dismantled and these two new pieces of legislation coming into play. And so I know personally I'm disappointed in the process with respect to the lack of consultation that we've seen prior to the bills being proposed, a lack of input on the bills when they were actually proposed, because they did go through 3 readings quite rapidly. And I think this is a common comment I think that many in the legal world comment on is the reliance on regulations to provide for the greater detail when much of the regulation should likely be in the Act and have gone through the thorough consultation and input process. From the perspective of local public bodies, I think they're looking forward to the opportunity of having some greater authority and some of the broader exemptions. And I think if applied properly, may be beneficial to the local bodies. But I will say that I was pleased to see some commentary in the Act about overly broad requests, because that's something that I think has been increasing, particularly in the last 5 years, with all in every document, with this topic or with my name, and the challenges of dealing with those requests with the increase in the volume of records that public bodies have because of technology. So I'm quite interested in seeing how the legislation will be interpreted and applied, particularly with respect to smaller public bodies, and also interesting to see how the fees potentially, if they get any kind of update as the regulation process kind of moves forward. With that, I do have a number of questions, and I'll start off with this one that I think relates to a bit to the changing and the different types of public bodies that are impacted by this. The right of access to information provision, as you indicated, provides a little bit more detail on a duty on the applicant, that they must provide enough detail to enable the public body to locate and identify the record within a reasonable time with reasonable effort. So that new wording of reasonable time and reasonable effort. My question to you, Commissioner, is respecting this new wording, how do you envision this section being interpreted? Is reasonable time with reasonable effort potentially an objective standard, or subjective standard considering the size and the resources that a public body may have?
Well, I think that's a really good question, Lorne. I guess we'll see how they're going to interpret that. When I see those words, as in FIPA, that term is a defined term, so that gives you, some sort of parameters within to make that interpretation. I have to be a little careful about those particular provisions because, as you may know, we are conducting an investigation right now of government as it relates to their processing of access requests. So, we'll see what happens with respect to how those are interpreted. I am concerned that it is going to make it difficult for people to get access requests in the door. So I guess, perhaps there'll be some clarification in regulation. The comments that I made now, which have, essentially been all over the media here in Alberta in response, and while the legislation was going through the House, the ministers were saying that they would be addressing my comments in regulations. So perhaps we'll see some clarification about the meaning of what it means to be reasonable when it comes to the ability to access information and how that will be interpreted.
Thank you. Yeah, there's so much in the regulations, I think, that we're waiting to see. I'll be really attentive, as Lorne mentioned. The devil's not just in the details, but in the supplementary regulations for the details. Samantha, I'll pass it to you for a comment and question.
Yeah, thank you so much, Commissioner. It was great to hear all your comments and to know a little bit more about the rationale behind these bills and sort of the next steps with timelines. With the PPA, I do see a lot of familiar concepts, obviously privacy by design principles, privacy management programs, and things like this. They're not new concepts. We've seen them introduced across a number of different provinces over the last few years. And I've also noticed that as they've been introduced in these provinces and other jurisdictions, there has been a little bit of confusion. There's been a lack of consistency with how, again, they're being implemented and whether organizations can really truly say that they're in compliance comfortably. Because again, similar to what Lorne had mentioned, different sized organizations and public bodies may have different resources to be able to comply with these requirements. And I do know that even in other provinces, some of the regulations that have been published to further detail privacy impact assessments and privacy management programs have been somewhat lacking and overly broad again. And so I'm just curious about what's the anticipated next steps for your office with providing, details and guidance around what these programs should really entail, and do you expect to provide documents or templates or anything like that as starting guides for organizations?
Right. So the detail around the privacy management program and what that looks like will be set out in regulation. So will the duty to prepare and submit privacy impact assessments. I'm not sure if, I expect that'll be kind of a layered approach to privacy impact assessments. So you may have to complete a privacy impact assessment internally in certain circumstances, and then you might have to submit those to my office in certain circumstances. So the work we'll be doing over the next few months is working with the department on the development of regulations. And so we will be providing them with what we think is a reasonable approach and scalable approach, to your point, to privacy management programs and the duty to complete and submit PIAs. And I always take the position that I don't want every PIA. I only want the ones where there's a public interest or some other kind of novel consideration or risk. I would like those to come to my office for evaluation. So we'll be working with them on that. Once we know what the regulations say, then we will, of course, be updating our guidance and resources. Now, I'm just going to qualify that with the fact that, we don't have a ton of resources. We are a relatively small office compared to other jurisdictions in Canada. But I do have a team that's dedicated to engagement. So we will be working as quickly as we can to try and get resources out there. And, I think we're going to start doing that work as soon as we have an indication of the framework that's coming forward so that we can assist public bodies with meeting their obligations. That's one of the key goals of my office is to be proactive and to help.
Thank you.
I know quite a few questions and quite a few conversations have raised the issue of the resourcing question for your office. And of course, this is something that's really actively on the table in Yukon right now, whether the changes to the law and the requirements of your office are met with sufficient resourcing. I think that's obviously you can't do that by fiat, of course, but it's pretty important for this, right? Especially given the shift in terrain. There's going to be a lot of interpretations and I think initial guidance that's required on this and a transition period. Lorne, I'll pass it back to you. Lorne, I got you on mute there.
Sorry about that. Yeah, another change to the Access Information Act is this provision relating to proactive and routine disclosure, where public bodies are able to identify and categorize certain information that will just be publicly available. And, I think in some ways maybe adds a positive step towards some greater transparency, something that maybe the exemptions maybe lack. However, in reading the provisions, it's clear the OIPC has no oversight over these types of decision, the categorizations. Two questions, I guess. One, what are your thoughts or comments about this new provision? And secondly, nonetheless, notwithstanding that you don't have the oversight, do you see your office providing guidance or resources to public bodies on how they should interpret and implement this new provision for proactive disclosure?
Well, there's several pieces to that question. I mean, the first thing is proactive disclosure is good. I mean, we encourage that. We want them to make information available without the need for an access request. But again, it depends on how it's going to be used. It could be a positive thing. It might not be a positive thing if they're trying to take categories of information outside of the access process. So I think it's a bit of a wait and see moment. And, obviously we hope that they'll use it the way it's intended to be used and not as a shield. And, in terms of our ability to provide resources, Lorne, it really depends. I mean, I think we have so much on our plate already. I asked for 8 new positions for this new, all of these new responsibilities. And as Mike indicated, we're talking fresh interpretations of both of these pieces of legislation. And I was given enough money for 2 people. And so, it's going to be difficult. We're really going to be stretched to trying to meet our obligations under the legislation. So, of course, we'd like to do that, but I'm not sure that'll be our priority.
Thank you. Back to Sam, and we'll have a couple final back and forth and some time for some questions from our audience as well.
I just have a clarifying question. On your discussions regarding the breach reporting notifications and the ROSH threshold, obviously it was a practice in the past for your office to publish breach decisions online, which was very different to what a lot of other commissioners in the past have done. In Quebec, for example, many times people are like, I don't know if this would be a ROSH standard or their standard, and at the federal level. And I'm curious, with this change of no longer publishing these breach decisions online, do you expect that the threshold that people are interpreting will sort of swing back in the opposite direction, and that typically the Alberta Commissioner's Office was conservative and found that ROSH was achieved in certain circumstances that maybe the federal commissioner wouldn't determine that? Do you think public bodies and private organizations even will go sort of the opposite way in just determining that we're going to be less conservative? We don't think this hits the threshold because we don't really have commissioner decisions now that are being published that prompt us to be more conservative in this respect. I'm curious to hear your thoughts on that.
There's a lot packed into that question, Sam. So first of all, it depends on the structure of the legislation. So Alberta has a unique structure in that, because we were the first, I believe, in Canada for sure, if not in other places as well, to require notification of breaches. So in Alberta, the responsibility under FIPA is to notify the commissioner if you believe that there has been a real risk of significant harm. The commissioner has the ability to make the decision and require you to notify. Most of the other frameworks in Alberta actually have the organization responsible for determining the real risk of significant harm and then notifying the commissioner that this has happened. So that is likely going to be what the framework is in the PPA. We actually have recommended changes to the FIPA as well, to have that same sort of framework, which is why we had all those decisions. So I chose to not publish those decisions anymore because we were having some problems. I won't go into all the details associated with it, but the spirit and intent of that provision is to ensure individuals are notified as soon as possible. And because of the finagling that was going on with some of the organizations that we were dealing with, they were content to say, no, ROSH, just Commissioner, you make the decision. So that's why I stopped publishing. So do I think that they're going to change their determination of ROSH, i.e., I'm assuming narrow those circumstances, what you're getting at? I don't know. But at the end of the day, we still have the authority to make that decision under FIPA. So if we get a report and we think that they actually should notify, we can go ahead and do that assessment. Under the PPA, it's not the same kind of decision-making. I don't have that kind of decision-making under the PPA. So it would have to be like a commissioner-led investigation if I thought that there was a problem, and then I'd have to determine what approach I could take. So I think that answers your question. I tried to cover off as many bases there.
Yeah, I appreciate that. Thank you.
Excellent. Lorne, over to you.
Yeah, sure. I'm gonna maybe put a loaded question out here a bit. From an access perspective, what do you think is going to be the most significant impact or unintended consequence of the new Access Information Act?
I think it's the access provisions themselves in terms of the ability to get access to information. I think the disregard authority is going to be exercised significantly more than I would have ever, I get the odd request to disregard, and very seldom does the public body meet the threshold. I think that the requests are going to be disregarded, they're also going to be abandoned. And that's what I'm very concerned about.
I agree 100% on that. It was a bit of a shock, I think, to read the legislation, look at those provisions, and just contemplate where that would go. And I'll be very interested to see how your office reports on the impact of this, next year, let's say. What will it look like to look back on the snapshot of these changes? Samantha.
I'm happy to pass it over to some of the questions on the chat. I know we have quite a few, and
Yeah.
we're running out of time, so I'm happy to turn to that if we would like.
I'd just like to make one quick comment in response to what Lorne had said about the consultation process. So one thing that I didn't mention, both of these pieces of legislation now have scheduled reviews. That is essential, because without those scheduled reviews, it happens within government. With the scheduled reviews, it has to go through the legislative committee process where it is public and there's consultation. So, and I agree with you, Lorne. I obviously was concerned about consultation, and but again, that's not up to me.
Yeah. Maybe just to add to that question, do you see the need for further public consultation or amendments based on the early feedback on this legislation, and potentially even feedback or consultation with the regulation?
Well, I think that's up to government to make that determination. One of the key things that I try and do is to make sure that I can sit at that table. And so if I can sit at that table, I have to actually ensure that I'm maintaining cabinet privilege during that process. So, it's not up to me to make those determinations. My job is to try and be at that table so that I can actually provide some feedback.
Maybe I could piggyback on that just as it pertains to consultations and kind of segue into some questions from everyone else here. Colin Bennett had posed a question about consultation on the Alberta PIPA. And perhaps to get your sense of where that stands right now, given the collapse of C-27 federally and the current kind of situation at the federal level.
All right. Well, hello, Colin. It's nice to know that you're in the crowd. So what has happened is, I don't have all the detail right in front of me right now, but it was in December. We appeared before the committee. It was their last committee meeting. They made, I believe it was 10 or 12 recommendations as to what they were recommending for amendments to PIPA. They did, indicate that they should look at what's happening nationally, also internationally. I do not think that they will stall on amendments to PIPA here in the province. One of the key things that is being talked about, or the comments that you're hearing sectorally, is that there's a need for harmonization in the province of the various laws. And of course, as the ambitions of government are to invest in research and development and scale up to market, you've got to have that synergy between the various laws. So I do think that PIPA will be amended. They made some excellent recommendations to amend PIPA. They're calling on it again to be the strongest privacy law in Canada. I hope that it is, but it also needs to facilitate the use of information, de-identified or anonymized information for different kinds purposes. So long answer to that question, but yes, the recommendation has been made. We have not yet seen the report. We expect that it'll be tabled in the legislature as soon as they come back into session at the end of February, I believe.
Fingers crossed. I'll turn to a question from the group joining us here from P. Walker. This is one that FIPA, our organization, has been talking about amongst ourselves as well. Are you aware, is anyone aware, of the drivers for removing the ability of public bodies to submit access requests to each other, which was an eyebrow raiser when we looked at the bill?
Yeah, I saw that in there, and I did question them about that in one of my comments. I'm not sure everybody agrees that public bodies actually have the ability to make access requests. So yeah, I really don't have much to say to that. I don't know why it's there. I don't know if it happened before. Lorne might know better than I do if that happens. So yeah, I'm sorry, I don't really have an answer to that question.
Yeah, it's an interesting comment, Mike, because I've only recently seen pushback on a provincial department not responding to a request because of that, which I was amazed by, and it seems to be driven by the new legislation as to why now the government won't respond to a request from another public body. To me, it was a normal process. It's one option to obtain information, particularly when there's a lack of cooperation between intergovernments, particularly between like a school board or a municipality and the province. So I'm not sure what the driver is, and I was quite surprised that it was even in there.
Yeah, I think we're going to be looking at that one closely on our end, seeing where and how that comes up. Considering you have for example, Métis Nation as a public body and a number of other organizations designated as public bodies who presumably might be interested in using access provisions to get access to important records. I have a question from Teresa G, and I'm going to apologize to everyone here. It's probably unlikely we're going to get to all the questions here, and I'm trying to curate these on the fly. But so this refers to Section 23(1)(2), and the question is, how would we go about ensuring that another person's compliance with the approved conditions for disclosure of non-personal data? How might that actually take place?
So 23, sorry, I actually have to go look at it. It's a very specific question.
Yeah.
Okay.
Ensuring compliance, another person's compliance with the approved conditions for disclosure of non-personal data.
Okay, so there is a provision in the legislation that requires a head to set out the approved conditions. So that actually has to be put into an agreement. So if you think about it, like I'll just use this example. A researcher can obtain access to information according to these particular conditions. So if there's some suggestion that those conditions have not been met, then that would be a violation as it relates to the non-personal data. One of the requirements is not to attempt or re-identify non-personal data. If that occurred, then that would be something that you can determine actually was non-compliance with the conditions. And in addition to that, there's an offense. There's also the ability to make complaints to our office about these data matching provisions as well, which would include if you think your data actually was not de-identified. So this is all going to be kind of new territory for us. And we're trying to figure out who's which department in my organization is going to take care of that. So we're looking forward to it. We think it's really important, but that's definitely new work for us.
Absolutely. Thank you. Yeah, that was a very laser focused question, but I think
it was
a good one. So another question I'll throw out here is because one of the themes that's come up in our conversation is the extended capacity of public bodies to disregard requests. There have been some questions about what happens in terms of fees associated with the request that then subsequently goes through a process of disregarding. How would that work?
I don't know. That's a very good question. I think that's maybe a question for government.
Okay. We'll compile a list of questions to submit to
Mhm.
to government as we go
Mhm.
forward on this. Excellent. Moving on then, and I will invite, of course, Lorne and Sam, if there are questions that you see that you'd like to jump on or pose, perhaps that you think are really particularly important, please do let me know. Question from Jason Waiwada, who's the executive director of FIPA, relates to the kind of absence of discussion of Indigenous data sovereignty or provisions in the Act that deal specifically with the disclosure of information that could be harmful to Indigenous peoples. And this is obviously a conversation that we're having across the country, certainly here in BC. What is everyone's thoughts on that, the lack of kind of a focus on this?
Well, I can just start by saying that I did actually make a comment about that in one of my set of comments and recommendations that went to government. That's all I can say about that. I do know that we are certainly having those conversations at the commissioner's table as well.
Good to hear, and definitely one that, again, we'll want to keep focusing on. Okay, so
I wouldn't mind raising one of the questions
yeah,
in the chat here and add to it a little bit. So Jennifer asked a question, will the OIPC as it's currently constituted be reviewing complaints and requests for review under both acts? And I think the answer in that is pretty clear. The legislation does indicate that anything that's under the old FOIP Act will still be processed under the FOIP Act. But I'm curious how your office is looking at balancing the different timelines, because the new access information, and I believe it's in the Privacy Act too, has a requirement for a request for or an inquiry to be completed within 100 days or within an extension of an additional 180 days.
Right.
So how do you reconcile the two different timelines in terms of, I guess, triaging and getting them to adjudicators given your limited resources?
Well, we already have 3 pieces of legislation that we manage, and so we build in various business processes and controls to make sure that we're managing our timelines. We have a case management system, so that helps us do some of that work. I think the bigger challenge will be meeting the timelines. Currently, under the legislation, we have the ability to extend. No, I'm not saying that's ideal, and it isn't. And obviously, a part of the suite of access to information rights under well, I guess ATI, but even privacy legislation, is the ability to access information in a timely manner. And I think that our system in Alberta is not meeting those objectives. We have lengthy delays, both at the public body side of the equation, and lengthy delays in my office as well. So that's something that when I became the commissioner back in 2022, that was one of my key focuses, is trying to look at our processes and reduce our timelines. And we're working really hard at trying to achieve that. And we will continue that work. We're trying to figure out how we're going to meet these timelines when the legislation comes into force, because we already have a significant backlog. So, never mind the differing timelines that we have to manage, Lorne, and that is part of the work that we have to do. We have to figure out how we're going to, complete these reviews within the now limited timeframes. And we're concerned that if we don't, we will end up in court about, loss of jurisdiction like we used to back in the day. And then, I think it went all the way up to Supreme Court of Canada. And we certainly don't want to go down that road again.
I'll pose an overarching question here, and this is for any of our panel and for the commissioner. What do we think about the decision to split the FIPA into these two separate bills? In addition to the content, of course, which we've been talking about, that was, I think, for a lot of people, a fairly surprising move, given that the conjoined legislation at the provincial level is the norm. This mirrors formatically the federal approach. Motives for this, implications going forward?
Well, I don't have a lot to say about that. I do think that there is some some value in privacy legislation being standalone to a certain extent. I think there was reluctance. This is my perspective. I'll just be clear, not my office's perspective. Reluctance to open up the act from the access side of the equation. But because the world of privacy is moving at such a rapid pace, there may be a need to be a little bit more nimble. And I think that might have been some of the impetus behind the split. One thing that I'm concerned about with the split, though, is the fact that the Protection of Privacy Act is supposed to be a standalone piece of privacy legislation, except the access rights are in the Access to Information Act. I find that troubling. So I'm not sure how well that's going to work out.
And Lorne, yeah, please.
Yeah, my comment would be on it. I've always looked at it and always described it to clients as it's essentially two pieces. Like the FOIP Act was essentially two pieces of legislation in one. And that responsibilities under access to information was different than the collection, use, and disclosure of personal information. So it didn't surprise me, or it didn't seem like illogical to split it. The one thing that I guess, and maybe this is another question back to Diane, is that in terms of the Protection of Privacy Act, I know views of how do you amend the act, is the current act's good enough? Are they technology neutral enough? The one thing that I see with this piece of legislation is it seems very specific to our current technological advances. Is this legislation neutral enough to deal with that rapidly changing technologies, or is the result going to be just continuous catching up as technology advances?
I see that the changes to the act, when we're talking about technology, to me, there's kind of two sides that we need to be considering. One is the privacy rights. And so the privacy laws need to embed those rights as it relates to the advances in technology. And as I said, I thought this act was missing some of those components. The mention of, using information to train automated systems, maybe automated systems will become this whole new definition and regulation to keep the pace. But the other piece of the puzzle is the actual regulation of, say, for example, artificial intelligence, which we have recommended to government more than once, that we need a standalone law in Alberta to regulate that technology. So, I don't know if that really answers your question. I don't know if we know at this point, Lorne. I think that, and that's why, I think it's important that we have the ability to modify the legislation to keep pace, because if we continue to let it lag, then that just creates all kinds of risks for individuals. And, we need to be much more nimble in the privacy landscape, because things are changing rapidly, and we don't even know what that's going to look like and what kind of impact it's going to have on us as individuals or as a society.
Mm-hmm. I was reflecting on some of the both your remarks, Commissioner, and also some of the remarks of the government when introducing the bills, and the emphasis on fees and the capacity fines for violations was certainly a highlight. And this kind of connects to a question that we've received about the powers of your office, or the ability of your office to ensure that any fines that are levied for violating or for breach are actually collected. Obviously, it's not fines coming to you, of course. But do you see the current state of affairs as being adequate for actually enacting those new fines or for breaches, or is there a need for additional resources there as well?
Well, so in terms of how it works is, so if we believe that there might be an offense that's been committed, we have the ability to investigate. So I would launch a commissioner-led investigation, and my investigators would investigate to determine whether or not that threshold of the offense has been met. They then have to present that to Crown. Crown makes a determination as to whether or not that's something they're going to proceed with. and then may lay charges at that point. So we've got, our determination about whether or not we're going to do it. We already are talking to Crown about these things before we get started, so we're not spending time that we shouldn't spend because the Crown's not going to go forward. So we have our office's resources, we have Crown resources. So those are challenging in and of themselves, even though we all think that, excuse me, breaches of personal information, health information is significant, they're also considering criminal offenses all the time. So there's only so many resources to go forward there. And then if it gets to the court, we find that the fines are quite low. So is this really going to serve the deterrence that's intended by these provisions? I'm not sure. I have certainly questioned it. I did recommend administrative monetary penalties. I'm not super surprised that I didn't get that in the public sector. I will note that the recommendations for the FIPA review include administrative monetary penalties, so that's good to see. But going back to your question, there's a whole bunch of factors that go into ensuring that these offense provisions have any effect. The other thing that I think is lacking is by the time it goes to court or there is actually a fine levied as a result of a plea deal, it's so far past the actual time of the event that the people that were there at the time when this occurred, they don't have any clue what the outcome is. Like, they're not making those connections. So I do think, while I think it's a good thing, if I had unlimited resources, if Crown had unlimited resources, maybe it might be more effective. But right now, it's just not.
Yeah. Lorne, do you have another question, or Sam, that you wanted to highlight for us? I was. Oh, please, Sam.
No, I just had a quick question regarding touching back on advancement of new technologies and the automated sort of decision-making notice that's sort of included in the Act now. I noticed that the notice is required where the information is input into an automated system, which I understand you're saying more information about what an automated system is may continue to be updated in the regulation. But it really refers to where it's used to generate content, make decisions, recommendations, and predictions. So I'm curious, there's a lot of AI tools out there that could be falling under an automated decision-making system to some extent, but not all features necessarily are really making decisions. And I'm curious about the generating content piece of it, because some of the systems used are just to maybe reformat information, but not necessarily generate new content. And so I guess, is the intention that when you're talking about generating content, is it purely generating new content based on that data? Or would you also be considering that as like reformatting and reorganizing existing content within a system?
I guess we'll see.
Okay. More regulations you anticipate that to be?
Well, again, I think that's a question for government in terms of, what was the intent of that provision? Until we get a chance to get in there and actually interpret these provisions, we don't know what they mean. I mean, we can sort of, have a sense for how we might end up landing in a particular place. But, you have to take everything into consideration when you're making those determinations. And as things change, so do those interpretations.
Okay. And I expect that those situations will likely be ones that might be targeted by the privacy impact assessment requirements, for example, and some sort of, in some respects, bias impact assessments in the future, as we've seen in other jurisdictions.
Yeah, I mean, that's certainly part of the recommendations, is not only privacy impact assessments for those kinds of technologies, but also the algorithmic impact assessments and also ethical review. I mean, those are the kind of the three key tools that we're advocating for when it comes to the development of that kind of technology.
I'm trying to combine a bunch of questions into some general themes here, and one that's come up a few times is this shift around timelines, the emphasis on 30 business days. I wonder if are there any thoughts from the panel on this, its implications, the reasoning?
I found it really quite interesting that they expanded it. Obviously, it's going to give public bodies a little bit more time and a little bit more flexibility to responding to requests. But I think the bigger concern isn't so much the change from 30 days to 30 business days, but and I know this is coming from a lawyer who's acting for public bodies, but it's that time extension of, I could take 30 days and then the additional 30 days. And then even if that's not enough, I could still take another extension for a reasonable period of time. To me, I think I have a greater concern with that because I know in making requests at the federal level, that almost makes receiving an access information request impossible, because you're getting departments that are replying with, "I'll get to you in a year." And I think to me, that's in terms of timelines, I think the 30 business days versus 30 days isn't really a huge issue. But I definitely have a concern with that. Yeah.
Yeah.
As reasonable a time extension as is necessary.
Yeah, as a professor, I have a lot of experience with requests for extensions, and the open-ended ones that can be endlessly renewable tend to be the problematic ones. Any other thoughts on timelines from the panel? I think Lauren covered that pretty well. Okay. Well, as we're coming towards a kind of a conclusion for this, one of the themes that's popped up in a number of the questions has to do with our expected timeline for the regulations when we're looking at that, but also, I guess, the possibility of an interim period, because we've got of course, we've got the law now, the bills that have been passed. We don't have the regulations, and there's going to have to be some work done on the PIA front, but also just on compliance, monitoring and relearning. Are we going to see an interim period where we're between these things? Is there going to be a grace period for organizations? And what are our thoughts on when those regulations are coming in?
Well, I can just give you some information. So we are scheduled to meet with the Department of Technology and Innovation biweekly for the next little while to start to work on the regulations. As I indicated earlier, is that we're told that May 2025 is when those laws will go into effect. Of course, that will depend if the regulations get completed. That's a very short period of time in which to develop these kinds of regulations. I know up in Yukon, it took us over a year, well, to government over a year to get all of that done. So that's what's happening with that. I believe in the Act, and there's so much going on in Alberta right now. I hope I'm not confusing the legislation, but I believe in the PPA, there is a grace period for the privacy management program. And I did raise a concern about that because I thought to myself, well, if they can leap out the door and do all this stuff with data matching and all of these things that are happening without a privacy management program, I had concerns about that. So, I'd said that, well, how about you're not allowed to do all of these other things until you have a privacy management program in place? So I believe there is a bit of grace period for that, but as far as I know, there isn't for anything else.
Wonderful. We have time for any closing thoughts from anyone on the panel, Commissioner Lorne or Sam, before I have a few final words on behalf of FIPA.
Well, I'll just say that I'm really grateful to get out here and talk to everybody and to get all of these really good questions. I mean, this is all new for us too, and we're learning. And every time someone asks me to talk about it, it's a great opportunity for me to dig into a little bit further. So I do appreciate that. I really appreciate my panelists, really good questions, and the people in attendance. And we have a lot of work to do in the next little while. And I encourage conversations with our office if there are questions. And we will do our best to provide those answers, and we'll do our best to get resources out there when we can.
Fantastic.
For me, I just say thank you for including me in the panel. I was feel very honored to be part of it, and I thought it was a great panel. On a personal perspective, I'm shocked that I won't be able to say you've been FOIPed anymore. I'm not sure what we're going to use for that acronym, or I would often refer that just the F word. And now I think we'll have to come up with something else that'll help explain the frustrations of these two new pieces of legislation. But it's going to be a lot of work, and not only for the Commissioner's office, but for the legal profession, and in terms of new arguments and new submissions on how these sections are going to be interpreted, and what these management plans are going to look like, and all the work with the PIAs. So I'm looking forward to it. It's adding a new challenge to the job, and it'll be interesting to see what the regulations bring out too.
Absolutely. Yeah, definitely a wait and see thing for us. Sam, I'll turn it over to you first, and then I'll conclude.
Oh, just thank you to everyone for attending. It's been a great session, and I really appreciate being included. Yeah.
Thanks. We appreciate all the expertise. One of the things that FIPA really tries to do as an organization is to have a real comprehensive and comparative assessment of all the different privacy and access laws across Canada. So, of course, this has caused us a lot of work over the coming months to see where things stand, but we are going to keep on top of it. For those who've posed some questions about when this will be available, Jason has dropped in the chat here some information about FIPA's podcast, Access and Privacy Online. And you can also go to FIPA's website, fipa.bc.ca, to see information about all of our different events, including this one. We're very impressed and very grateful and humbled by the interest in this. I think it goes to show the importance of these changes. And so we'll make sure everyone has access to all of this going forward. Thank you very much, and thank you also to our hosts, Kwantlen Polytechnic University Faculty of Arts, for facilitating a lot more than our humble little Zoom account could in terms of number of participants here. Thanks very much to the panel and to the Commissioner for joining us today, and I wish you all well.
Thank you.
FIPA's work encompasses legal research, public legal education, public assistance and aid, and law reform that focuses on transparency and privacy issues. If you're interested in these issues and you'd like to learn more, or if you'd like to contribute to FIPA as a donor or become a member of the BC Freedom of Information and Privacy Association, I encourage you to visit our website at fipa.bc.ca. You'll also find us on Facebook, Twitter, LinkedIn, and YouTube. Thanks very much.